Related. Go ahead, Delmar. Read Delmar for me, please.
Related duties. That is what's on the JD. So
Any
related
other,
duties.
any other related
Right.
duty. So that makes it different now. So
All right.
that then, Delmarie and other colleagues, I'm going to ask you, do you believe if the individual is not executing any of these other related duties properly, you can include it in a PIP? Can you include it or you should leave it out? Remember, the JD has some specific duties which are outlined, and then as Delmarie says, there's any other related duties. I'm asking if you can just give the person something, to do, which is linked to one of their JD, their responsibilities, their core responsibilities. Can you put them on a PIP for those duties which are deemed to be related to their core job functions?
For me, I would say no.
You would say no.
I would say no because this is not. This duty may not be something that you are doing on a regular basis, as per your JD. So I would say no. If it is something that is given to a worker, an ad hoc responsibility, I can't now go and penalize this person because he or she has not performed or done up to what it is. It simply means that
it happens, Delmarie.
if it's something, but if it is something that going forward, then it must be included in the JD.
Very good.
But if it's ad hoc responsibility, I can't charge a person for it.
Very good point, Delmarie. Colleagues, you agree or you disagree with what Delmarie is saying?
I'm in agreement because if this is the add-on, I've never done it before, and you give it to me and I don't perform.
You're done it, but you're executing to the level where the team leader or manager wants it to be done. Right? And they may not be frustrated, and as a result, you end up being scrutinized. Right? So this is something which you have to be mindful of. And as Delmarie rightfully said, if this duty is so critical or this responsibility, it needs to be clearly stated in the JD. You may have to revise the JD now. Other colleagues, are you following? Are you clear on what we're saying?
I agree. Once it's not the core function in the JD, then I'm in agreement.
Yeah, I'm in agreement. But how does that impact on job enlargement, though? And if that's been devil's advocate when I'm asking that question.
No, job enlargement, what do you mean by enlargement?
All right, after 5 or 10 years of doing the same duties, one can become bored and everything becomes so monotonous. And I want to give you more senior duties and responsibilities to do.
With more money, right?
No, you're getting experience.
Oh. Okay, go ahead. So, no, but the fact is this, job enlargement, you're talking essentially to expand the person's function, but that doesn't just work that simply. Is it going to be a promotion?
No, you're just getting additional duties.
Karen, colleagues, do you agree with what Karen is saying?
No, I disagree with that because additional duty would mean that you need additional pay or pay increased.
But like I said, devil's advocate, because we do that here. Let's not be naive.
Those are the things that
So I'm asking.
Be careful, Karen, about the statements you make on the platform. But it's not just to give the persons more responsibilities. The fact is this: our department may evolve over time because as certain trends in the workforce changes, and as the company itself evolves with the technology that is now in place and which is to come, and with certain production functions and so on, you may want to change some duties on certain individuals' JDs. I will say to you, colleagues, that requires a conversation. And ideally, I will say to you that if you intend to expand an individual's function, you need to ensure that there is additional compensation, even honorarium, because staff order speaks about that. You give them something for the additional duties. And I had a case recently with a public entity. There's a person who was the operations manager for a region, right? And the JD mainly outlined duties pertaining to monitoring, coordinating, overseeing, and doing reports and so on. And this individual had, I think, 4 persons at the sub-regional level reported to that person. And at one point, one of those persons were fired for whatever reason. I didn't get the reason. But the chief ops person now had to improvise by going to that region and doing the paperwork, the groundwork, doing the field checks, like a field officer, going to locations or whatever it is, for about 14 years. And the argument now is that, look, apart from doing the directorship work, he had to work as a field officer as well. So he's requesting some additional compensation as a result of those additional duties. All right? So we have to be very careful how we treat these things. If
So
the person,
Dr. Sharp, was it in favor of him getting more pay?
no, he didn't get more
That
pay.
case?
It didn't get more. It didn't get more from the employer because they're saying that, look, because you're the more senior person, you should have these expertise to go in the field and do it. We're not paying you anymore. We're not going to employ anybody. So you're going to carry this particular sub-region along with your substantive duties. And you did that
But
for
Lauren, for 14 years,
14 years.
Dr. Clark,
14 years.
Dr. Clark,
Marsh.
Marsh,
I'm sorry. Yes. Tracy Fakuri here from NEPM region.
Hi, Tracy. I didn't have you down.
Yes. So I would like to ask a question just for clarity purposes. So I dare say, stand to be corrected, but all our contracts end with the clause that says, and any other related duties.
Right.
So do I understand what you're saying to mean that the related duties must be in relation to the person's JD?
And specified. So it's not just to keep the clause there and then do as you please. The person may ask Starty, what do you mean by related duties? And you may have to outline those duties. Or it can be an arbitrary case where you just simply tell the person what to go and do when you choose. You show them the duty, you explain the duty that is related and of course what it requires. But if it is a case where the person is now giving more, I am sure, colleagues, 100% that they can make an argument that they need more compensation, especially if it involves traveling to another location away from their substantive place of work.
For clarity, Dr. Marsh, I said you already mentioned that we have to consult with the individual. What if can the said individual refuse that this related duty legally?
They can refuse it because they're on their JD, and that is a very good question. They can. It has happened before. Good. And essentially, no, you have to negotiate with the individual, have the conversation. Again, keep your records, but eventually, based on my experience, colleagues, if the person decides not to do it, you can't fire them. Unless there's a performance release and you decide to take action. But what happens usually is a mutual separation because the person is deemed not to be a best fit for the position. But it's a very sensitive process.
Well, you just said mutual separation. That means that we can just come to an agreement that, hey,
Yes.
this is not working out for you.
Not working out.
What if I want to wait until the end of the contract, though, Dr. Marsh?
Do what? Well, the truth,
not renew on the basis that you are refused the additional duty.
Yes, the truth is this, colleagues. There's no such thing as contract break. Do you know that?
Yes, I'm aware.
What do I mean by Karen? There's no such thing as contract break. What do I mean by that? Anybody can comment.
In my opinion, your contract comes to an end. At the
Comes
end
to
of
an
your
end.
contract,
Very good.
you're no longer employed to
Right.
the
All
company.
right. So there's no break, and that's what I'm saying. Persons who are management and HR. When a person is approaching the end of their contract, you would notify them, say, a month before or whatever period. But do not make any promise in the letter when you're severing the employment relationship that you intend to call them back next date or whatever. That's not a safe thing to do, because once the contract ends, you have absolutely no obligation to the person unless you owe them some compensation for whatever benefits they did not reap while employed. So, for example, vacation, which is a contract end. Desist from using the term contract break. If you say break and your case is like this, it gives the impression that the person will be recalled. Wrong or right?
Right.
All right. So moving on. Regarding the PIP, when to implement a PIP. For the new employee, of course, and I did a presentation this is the probationary period. The fact is, colleagues, details are the PIP can be used within the 90-day period if deficiencies are identified. I will say to colleagues that move away from the notion that if a person is in the probation period, you can simply send them home. It doesn't work like that anymore. All dismissals have to be rationalized. What do I mean by that?
Miss Russell?
Narika? Narika? Not hearing from
No, it was
Narika.
me, it was me, Dr. Marsh. It was
I'm
kind
here,
of,
Dr. March. What do you mean by rationalize that? You can't just, as you said, terminate an employee like that. You have to
Without
go
reason,
different,
also?
yeah, without the reason. You have to go through the different procedures. So, but they're going to
Right.
the first, or they're going to go to disciplinary, but you can't
Right.
just terminate an
Right.
employee based on performance or feelings or whatever.
Whatever it is, right. So what we in Jamaica, we speak about dismissal for cause, right? And we are strongly against dismissals which are unjustifiable. Justifiable means, huh?
Sorry, Lauren. So the disciplinary process comes within that 90-day period?
It does. It should. And I'll give you some examples, Marie. So let me tell you now, with performance, you might be a bit safer because you might save you from going through the rigors of the disciplinary process. If you take on an employee, you give them their JD, you onboard them, you give them relevant information and policies, you realize a month though they're not performing, and you have the conversation, you meet with them, you have the memo, you do what you need to do, you guide them in the right direction, but they're still not performing. It's a safer route to say before the 90th day to say, look, it's not working out and whatever, right? But if you say nothing at all and try to send them home on the 89th day, you may have a problem, right? Adele Marie, how long is your probation? 6 months, up to 6 months. Is it 6 months or is it 90 days for you guys?
90 days.
We do the 90 days, but we give extension for another 90 days.
Right, 90 days. You can do that based on the staff orders. But here what happened now with you, if you intend not to keep the person in the probation period, you have to give them a month, at least a month notice, you know that?
Dr. Sharp,
Yeah.
documentation is saying that, but think about it, especially if the person is in a critical area. I'm supposed to tell you at 2 months.
A month.
My procedure, Dr. Sharp, is that after onboarding everything.
Marsh, Karen. Marsh, M-A-R-S-H.
Okay, Marsh.
Right.
Dr. Marsh. After onboarding, and you would have this on the job training period with the person to go through to make sure that they're understanding and you set your parameters, etc., etc. I normally like to do a 1 month sit down to say, okay, are you doing it right, etc., etc. I go back in at 6 weeks.
Like a midpoint check-in.
Excuse me?
So like a midpoint check-in, we just meet with the person.
Yeah, and I follow that. No, so between 1 to month 2, I would have met with you 3 times. Month 1, 6 weeks, and at the 8-week marks. At the 8-week mark, there's no improvement, nothing. You're in a critical area. And I must serve you notice to say at the end of the next month, I'm firing you.
Well, yeah, guess what? I understand, Karen, I get you. And that is, and the truth is too, the person can create a lot of damage in that time frame as well too. So
Exactly.
but it's what the staff orders prescribes. I don't necessarily agree with it, but I'm just sharing the information that exists in law. All right. Well, in policy, because the staff orders is a policy, it's not an act, it's a policy, a government policy. But the fact is this though.
Lauren,
Yes, Delmer.
Lauren,
Yes, yes.
what you call notice?
Notice.
Because
So,
this person is working with me for 2 months, right? Based on the labor law.
2 months, right?
You, the person can decide you don't want to work anymore. The company can say, I don't want anymore. So what is this notice?
The notice they're referring to is the notice period before the person is dismissed. So it's usually for, if it's under 5 years, 2 weeks. Notice they get, or pay in lieu of notice.
Within the first 90 days?
Yeah, man, because here what happened now, Delmarie, this particular legislation, the Employment Termination Redundancy Payments Act, although it shouldn't apply to you in the public sector, but this is referred to all the time. But it says that once a person is employed 4 weeks or more, that's what the act says, right? Then they're entitled to whatever. 2 weeks for up to 5 years, then it says 3 weeks and it goes on. But they will be entitled to notice pay. That is the practice anyway.
But then, but
Oh, okay.
re-educate me, please.
All right.
Re-educate
Let
me.
me show you. Let me show you something
Yes.
quickly. All right, hold on. Let me show you this. What the act contradicts itself because it says in the first instance that if the person is not on probation, they should work 4
Exactly.
weeks before they get the notice pay. But it goes further and it contradicts itself. Hold on, let me find the presentation from yesterday because we're talking about that in it. Let me pick it up.